Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about the difference between independent administration of a probate estate and supervised administration of a probate estate. We have a lot of articles about probate on our website at learn-about-law.com, so if you want to learn more about what probate is or the probate process, you can go to those articles. But basically, probate is a court case that's necessary if you haven't done a proper estate plan. And if the probate case is necessary, the court oversees the distribution of assets to heirs and creditors. In an independent administration of a probate estate, the executor has to get court approval for much less than they would in a supervised administration. So they basically only have to appear in court twice, once to open the estate and later to close the estate, about a year after they open the estate. They don't have to go to the court for approval of liquidating assets or paying creditors or distributing assets to heirs. In a supervised administration of the estate, the court oversees almost every aspect of the case, and the executor has to go to the court for approval of most of their actions, and they have to file reports with the court that they wouldn't have to file with the court in an independent administration. And we'll go into more detail later about what exactly the logistical difference between independent and supervised administration is. But first, let's talk about what triggers a supervised administration. So by default, all estates are independent administration. If no one requests or the court doesn't appoint or order supervised administration, you can expect to have independent administration. But the two ways that a supervised administration can be triggered is either by the court ordering it or an interested party requesting it from the court. When does a court order supervised administration? So the court will take it upon themselves to order that the case be handled by supervised administration if there's a minor or a disabled person involved as an interested party, because they can't protect their own rights as against the executor, so the court wants to make sure that they oversee the distribution of assets to ensure that this minor or disabled person's rights are protected. And in that case, the court will just take it upon themselves to order that the case be handled through supervised administration. If the court doesn't order supervised administration, any interested party, a creditor or an heir, can request supervised administration. So then the next question becomes, when is supervised administration granted upon request? And that really depends on whether there's a will in place and what the will says. So you can have a will in your estate plan that explicitly provides that the estate is going to be independently administered. And if you do that, if you have a will that explicitly provides for independent administration, then anyone that requests supervised administration, they can still request it, but if they request it, they have to show good cause for the supervised administration. And the court has wide discretion as to what good cause could be, but they have to show some reason that the executor can't be trusted to administer the estate independently. If there is no will in place, or if there's a will in place that doesn't explicitly say that the estate's going to be independently administered, then supervised administration is automatically granted by the court upon request by an heir or a creditor or any other interested party. So if you don't need to go through supervised administration, if the court doesn't require that, then, like I said, most estates are administered independently. And in that case, if your estate's administered independently, if you're the executor, there's a thing called an accounting and an inventory, and those basically are reports that list the assets that are collected by the executor and how they're going to be distributed, and the debts and liabilities of the estate. And those reports still have to be provided in an independent administration. They have to be provided to interested parties like heirs and creditors, but they don't have to be filed with and approved by the court. And also the executor in independent administration can take most actions without court approval. So they can sell property, liquidate assets, collect assets, pay creditors, pay heirs what they're due under the estate. They don't have to get court approval to do this. They have to list all of this in the accounting and inventory and provide this to the interested parties, and if interested parties object, they can bring that to the court. But if there's no objection, then, like I said earlier, the executor only has to appear once to open the estate and a second time to close the estate, and everything that the executor is doing in between can be done out of court. If a supervised administration is ordered by the court, then the executor, in addition to providing the inventory and accounting to the interested parties, also has to file it with the court and have it approved by the court, which can be a difficult process. They also have to seek court approval before making any major decisions, like paying creditors, distributing assets to heirs, liquidating certain assets, selling real estate. Minor tasks like paying utility bills and mortgage bills, they can still do without court approval. But again, you want to think of it as the court is the watchdog in supervised administration, and they want to be in on all major decisions. In independent administration, the executor is trusted to handle those major decisions on his or her own. So supervised administration can be a good thing if there's a lack of trust between the executor and other interested parties. So if a creditor doesn't trust the executor to pay them properly within the estate, or if there's a family dispute and the heirs don't trust the executor to handle the estate properly, supervised administration can ensure that everyone's rights are protected by the court. However, it is more costly because there's a lot more work that both the executor and the executor's attorney has to do. So the estate's going to be more expensive in supervised administration, which means there's going to be less money going to the heirs because the attorney's fees and executor's fees are going to come out of the estate. So it is a negative in that respect. And also, supervised administration estates tend to take longer, so there's a delay because the executor has to keep going back to the court for approval, and because there's a lot more work involved, the payouts to heirs and creditors happen a little bit more slowly in supervised administration. So if everyone can get along and everyone's on the same page, independent administration is definitely a better, cheaper, faster way to go. But like I said, sometimes that's not possible if there's a dispute between heirs and the executor, and then you need the court to step in and supervise the administration of the estate. If you're preparing your estate plan, there's a couple things you want to keep in mind. One, if you use a proper trust strategy, you can keep your estate out of probate entirely. So that's kind of beyond the scope of this conversation, but we have lots of videos and audio and articles about proper estate planning at learn-about-law.com. But even if you don't want to bother with a trust and keep your estate out of probate, like I said, if you provide in your will that your estate is going to be administered independently, that provides some protection to your executor, and anyone who wants supervised administration is going to have to show a pretty good reason for it. So, thank you for listening. If you have any other questions, you can call my office at 630-324-6666. We do a lot of probate work, and we offer free initial consultations. And if you want to learn more about probate or estate planning or any of the other areas of law we practice, which is most of them, you can go to learn-about-law.com to check out more podcasts, videocasts, and articles on all these subjects. I also host a podcast for business owners called seizeyourbusiness.com, where I interview business owners about their business strategy. So if you're a business owner, you might want to check that out. Thanks for listening.